Talk Show.
Recorded live.
Hello, ladies and gentlemen. I want to bring a topic to you, and I want you to think about it. The topic is the Nuremberg trials. There were two sets of trials. Actually, there was more than that. But there were two different types. One did the military for war crimes, but the other one dealt with the private citizen, the government. And what got me thinking about this is that Spencer Tracy movie, Nuremberg. Ladies and gentlemen, you need to go back and watch it. What we are running into, I believe, in these courts, and why nothing works. And even though you're trying to do Admiralty, Maritime, UCC, and we're trying to use the Constitution and the statutes and the rules and regulations, what we're finding out here is this. They're not abiding by any of it. They do what they want, when they want, how they want, and if they choose to allow you to win, then you do. And the reason why we're bringing this up, because something was stated in that movie, and it rang a bell with what we're running into. We know for a fact, in every single court case, there is never a plaintiff that sits next to the prosecution, or very rarely does. Put it that way, very rarely. All the charges are in the name of the state, in the name of the government. In this Nuremberg trial, what the Nazis were being tried for was the fact that the judges and the prosecutors, when they switched over to the Nazi party, they changed their form of jurisdiction in that courtroom. And that's what we're running into today. What was brought out is significant, is that the people in Germany at that time period, and the parallel is today with what we're doing, is you're being charged for crimes against the state. There doesn't have to be a complaint. There doesn't have to be an injured party. We're being charged for crimes against the state. And ladies and gentlemen, that creates a problem here. Because when you're being charged for crimes against the state, there's no defense. There is no defense. And what they were doing in Germany is that they were singling out people, groups, whether it was religious, whether it was deformity, whether it was political, whether you just had a different opinion. They could charge you for crimes against the state, and they didn't have to have any evidence other than the fact that they drugged you in. Ladies and gentlemen, that's exactly what's happening in these courts today. I pulled up some information here, and it was on the Soviet Union, 1958. In Soviet criminal law, the most grievous crimes, transgressions against the most important interests of the Soviet state. Liability for crimes against the state is established by an all-union law. All-union law. Did you stop to think here for 1 minute that all these public officials are under a union? We talked about this some time ago. They got their own union. They got their own little clique. Crimes against the state are divided into two groups, especially dangerous crimes and other crimes. Especially dangerous crimes, state crimes, or acts or omissions aimed at overthrowing, undermining, or weakening the Soviet socialist and state system. They include high treason, espionage, terrorism, sabotage, wrecking, anti-Soviet emigration, and propaganda, war propaganda, organization of activities for the purpose of committing especially dangerous state crimes, in particular in an anti-Soviet organization. Similar crimes directed against other Soviet states are also punishable. What this boils down to, what we are trying to do to gain our freedom and what we are exposing puts us right in that category, that we are being charged for crimes against the state. because we don't share their opinion that we should bend over and take a hosing and be thankful for it. The fact that we're standing up and saying, wait a minute, we have an issue here. We have two classes of people. One, employer. Two, employee. If there's any doubt that we need to go down to the election board and find out who put their name on a ballot as an employee to work for us, the government, the people. Because, ladies and gentlemen, we are the government. They are employees and agencies of that government, but we are the government because we are the ones that put them in office. Second, crimes classified as other crimes, including a large group of acts that infringe on such political, economic, and other state interests as national and racial equality. The military strength of the USSR, the involuntary of the country's borders, the foreign trade monopoly, and the monetary and credit system that normally operates the railroad, water, and air transportation and public security. Ladies and gentlemen, specified crimes including state secret or lost documents containing secret states, illegal leaving or entering the Soviet Union, violating international air regulations or safety regulations in public transportation, barratry, and mass disturbance. Most of these crimes involve intent, but the intent does not have a direct anti-state organization. Ladies and gentlemen, what we're walking into, I believe, and I want you to just sit back and just think about it, is the fact that we're being charged in these courtrooms by the state for state violations. This is why we're having a problem trying to put up a defense. Under the law of necessity, doctrine of necessity, the principle that the law of an illegal government shall be deemed valid insofar as they do not contradict the Constitution, justified on the basis that maintaining a government is of greater ulterior value than maintaining of the law. Ladies and gentlemen, this is what we're running into. The principle that in a situation of emergency circumstance, a state may legitimately act in a way that would normally be illegal. The principle that a state is immediately peril due to an existing from a situation not of its own doing may justify in violating of rights of other states. Ladies and gentlemen, we're in that state of emergency. We're being charged for crimes against the state. This is part of the problem why none of this stuff works. It wasn't until I sit here and watch the movie did it dawn on me what they were actually doing and how they're getting away with it. But ladies and gentlemen, these are crimes. These are crimes. I want to read something to you here a minute. And it came out of the Nuremberg setup. And it is under the Nuremberg laws that were created at that time period. And it's called the Nuremberg Trial Final Report, Appendix D, Control Council Law Number 10. Punishment of person guilty of war crimes, crimes against peace and humanity. Article 2. Any person without regard to nationality or the capacity in which he acts is deemed to have committed a crime as defined in paragraph 1 of this article if he was a principal or was an accessory to the commission of any such crime or ordered or abetted the same or took a consensus part therein or was connected with planning or enterprising involving its commission or was a member of any organization or group connected with the commission of any such crime or with referred to paragraph 1 if he held a political, civilian, or military, including general staff position in Germany or in one of its allies, co-belligerents or satellites, or held high position in the financial industry and economics life of such country. This was in Germany. Ladies and gentlemen, this still falls back into crimes against peace and crimes against humanity. What's being done here and what is being exposed here on this, and what has just recently hit the news on the financial fraud on this, sits here and gets into bombshell. The secret lawsuit has finally been revealed. Your mortgage documents are fake, and your foreclosure is a fraud. There is a website that just come up, and from what I understand, this hit the newspaper, or hit TV here. A newly unsealed lawsuit which banks settled in 2012 for $95 million actually offered a different reason, providing a key answer to one of the prestigious riddles of the financial crisis and its aftermath. The lawsuit stated that banks resorted to fake documents because they could not legally establish true ownership of the loan when they tried to foreclose. Ladies and gentlemen, we know this goes into deeper than that. We know that this goes into the signature. This goes into securitizing, goes into bondage, and we know that the courts are doing the same thing. We know the courts are selling us through the Chris account and through other means in these courts. But ladies and gentlemen, what is important here is the fact that we need to start waking up, because we're being charged for crimes against the state. And in Nazi Germany, all you had to do was be the wrong religion, have a deformity, have a different opinion than what the government told you to have. And that's what we're running into now in this country of ours. And these are war crimes. These are crimes against humanity. This is human trafficking because they're selling us. There were several case laws that I pulled up. Perry versus United States. One of our callers sent this over to me, and it was a very valuable piece of information because it went into several other categories with other case laws that came back in and opened up the bankruptcy of 1933. Because what it did, it went in and talked about the state of emergency. I want you to look up Perry versus United States. That's Perry versus United States. I want you to look up United States versus Bankers Trust Company. That is United States versus Banker Trust Company. And you also will run across Norman versus Baltimore and Ohio Railroad Company. And the other one is Norsec, N-O-R-T-Z, N-O-R-T-Z versus United States. These four case laws, actually it's three, but these four case laws go back and address the state of emergency of this country being bankrupt. This is where that state of emergency comes in. This is where the crime against the state is coming in because they're covering up. They are covering up the bankruptcy and the embezzling that they are doing. These cases are very significant. Like I said, Perry versus United States, Norzek, N-O-R-T-Z versus United States, United States versus Bankers Trust Company, Norman versus Baltimore and Ohio Railroad Company. These are very significant cases, very significant, because it actually goes in and talks about the bankruptcy. It actually goes in and lays out what they're talking about. A provision in a government bond for payment of principal and interest in United States gold coins of the present standard of value must be fairly construed and its reasonable import is an assurance by the government that the bondholder will not suffer loss through depreciation of a medium of payment. This is Perry versus United States. The joint resolution in June 5, 1933, which was at HJR 192, insofar as it undertook to nullify such gold clauses in obligation of the United States and provide that such obligation shall be discharged by payment, dollar for dollar, in any coin or currency which at the time of payment is legal tender for payment in private debt, is unconstitutional. Congress cannot use this power to regulate the value of money so as to invalidate the obligation which the United States has therefore. Issue in the exercise of the power to borrow money on the credit of the United States. There is a clear distinction between the power of Congress to control or interdict the contract of private parties when they interfere with the exercise of its constitutional authority and the power in Congress to alter or replicate the substance of its own engagement when it was borrowing money under its constitutional authority. Borrowing money off of us. We're the credit line, ladies and gentlemen. By virtue of the power to borrow money on the credit of the United States, Congress is authorized to pledge that credit as assurance of payment as supplicor as high assurance to the government can give. To say that Congress may withdraw or ignore that pledge is to assume that Constitution complainment a vain promise, a pledge having no other satisfaction than the pleasure and convenience of the pleasurer. When the United States, with constitutional authority, made contracts, it has rights and insurance responsibilities similar to those of individuals who are parties to such instruments. The right to make binding obligation is a power of sovereignty. The sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will as directed, as declared in the Constitution. Holy crap, people, did you hear what I said here and said it's in this case law? FBI, listen real close. Sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. Did you hear that, Mr. FBI? Did you hear that, Mr. Police Officer? Oh, you're one of them sovereign citizens. The sovereignty of the United States resides in the people, and Congress cannot invoke the sovereignty of the people to override their will as declared in the Constitution. The power given Congress to borrow money on the credit of the United States is unqualified in virtue to the government, and the binding quality of the promise of the United States is of the essential of the credit pledge. The fact that the United States may not be sued without its consent is a matter of procedure which does not affect the legitimacy and binding character of its contract. Section 4 of the Section 4 of the 14th Amendment declares that the validity of the public debt of the United States authorized by law shall not be questioned. It is confirmatory of a fundamental principle applying as well to bonds issuing after as to the issue before the adoption of the amendment in the expression validity of the public debt, embracing whatever concerns the integrity of the public obligation. The holder of a Liberty bond, which was issued when gold was in circulation and when the standard of value was the gold dollar at 25.8 grams, 9/10 fine, and which promised payment in gold of that standard claim payment after the government pursued the legislative authority was withdrawn in gold coins, and from circulation has prohibited its export or its use in foreign exchange except for limited purposes under license, and has reduced the weight of gold representing the standard dollar to 15-5.21% grain, and placed all forms of money on the party with that standard. The joint resolution of June 5th, 1933, again, which was HJR 192, had enacted that such bonds should be discharged by payment, dollar for dollar, in any coin or currency at time of payment, was legal tender for public and private debt. The bondholder having been refused payment in gold coins of the former standard or in the equal weight of gold demanded currency in the amount exceeding the face of the bond in the same ratio that was bored by the number of grams in the form of gold dollar to the number of existing one, or $1.69 of currency for every dollar of the bond. The Treasury declined to pay him more than the face of the bond in currency, and he sued in the Court of Claims. The fact that the government repugnance of the gold clause of the bond is unconstitutional does not entitle the plaintiff to recover more than the loss of his actual suffrage, and of which he may rightfully complain. The Court of Claim has no authority to interact in action for normal damages. A question of actual loss cannot be determined without considering the economic condition at the time when the government offered to pay the face of the bond in legal tender currency. Congress, by virtue of its power to deal with gold coins as a medium of exchange, was authorized to prohibit its export and limit its use in foreign exchange, and the restraint there imposed upon holders of such coin was incident to their ownership of it and gave them no cause of action. The court cannot say that the exercise of this power was arbitrary or capricious. The holder of a bond of the United States payable in gold coin of the former standard, so far as concerns the restraint upon the right to export the gold coin or to engage in transactions of foreign exchange, it is in no better case than the holder of gold coins itself. In assessing plaintiff's damage, if any, the equivalent in currency of the gold coin promised can be no more than the amount of money which the gold coin would be worth to the plaintiff for the purchase for which it could legally be used. Foreign dealings being forbidden, save under licenses, and the domestic market being not free but lawful restriction by Congress. Valuation of the gold coin would necessarily have regarded to its use as legal tender and as a medium of exchange under a single monetary system with an established party of all currency and coin, and this would involve the consideration of purchasing power of the current currency dollar. Plaintiff has not attempted to show that in the relationship by buying power he has sustained any loss. On the contrary, in view of the adjustment of the international economics to the single measure of value as established by the legislation of Congress and the universal availability and use through the country of the legal tender currency in meeting all engagement, the payment to the plaintiff of the amount which he demanded would appear to constitute not a recouping of loss in any proper sense, but a justifiable enrichment. Ladies and gentlemen, this document falls back in and clearly shows that you and I were classified by the court as the sovereigns. That means that we cannot be sued in these courts. We cannot be sued in these courts the way they're doing it. This is why they're bringing us in on crimes against the state. They're bypassing all this. But ladies and gentlemen, I would download this Perry versus United States, because I tell you what, this is a very, very significant document. And that's the same thing with, I would download United States versus Bankers Trust Company, NORZAT, NORTZ versus United States. Let me go back and pull this one up and let me read it. I wish I could read a little bit better than I do. But I want you to go back. I want you to pull this stuff up yourself. I want you to go back and read this, because this is some interesting stuff. A demur to a petition in the Court of Claims admitted facts well pleaded, but not alleging amount to a conclusion of law. A gold certification that there had been deposited in the Treasury of the United States, a state number of dollars payable to the bearer on demand, in which is legal tender for public and private debt, is not a warehouse recipient or a contract for a certain amount of gold as a commodity, but is currency. Query whether the issue of a gold certificate creates a express contract upon which the United States may be sued in the Court of Claims under Judicial Code Section 145P. The Court of Claims cannot entertain a claim for normal damages. Congress has complete authority over the currency system, including authority to provide that all gold bullion, gold coins, and gold certificates outstanding shall be taken over by the government. Ladies and gentlemen, these are the people that we need to go bring a claim against. They're the ones who has absolute control over the gold. Remember those SS-95s that we're talking about? Assuming that the holder of the gold certificate who, prior to the devaluation of the dollar, was required under the Emergency Banking Act and Treasury order to deliver the certificates to the Treasury, was entitled by its terms to receive the amount of the credit of gold coins of the then existing standard of weight and fineness. It cannot be said that in being obligated to accept payment dollar for dollar and legal tender currency not redeemable in gold, he suffered any actual loss, since if the gold coin had in fact been paid him, he could not have held it as a default in it, having no license, but would have been compelled to surrender it to the Treasury for the same number of currency. In a suit in the Court of Claims for damages, claims have been made because of refusal of the government on January 17, 1933, to pay a gold certificate in gold coin and substitute other currency dollar for dollar, an allegation that gold was at the value of $33.43 per ounce necessarily involved a conclusion of law, since under appropriate legislation requirement, they were not on that. Date a free market for gold in the United States or any other market for the gold coins claim or any right of person unlicensed to deposit abroad. Responsibility to question propounded the Court of Claims arising out of the claim based on gold certificates. Ladies and gentlemen, this goes right back into where that Federal Reserve note is a promise, and that's what McFadden was sitting here saying. So they took our gold based on a promise. This is where the issue comes in, ladies and gentlemen. This is where the issue comes in. Let me find another one here. This United States versus Banker Trust. The first one I read was Perry versus United States. And the other one was Norton at NORTZ versus United States. But get into these, ladies and gentlemen, because I tell you what, there is a wealth of information in here that can be used on what we're dealing with. And this is why they don't want you to go past 1938, because some of these case laws that dealt with this issue is sitting in some of these case laws. Yeah, this one's real long. I'm not going to get in and read this one. But ladies and gentlemen, I'm giving you some more case laws here to go look up. Very substantial case law. Very substantial case law. But these courts are running under what we sit here and talked earlier. We're being charged by the state. That's crimes against the state. There's no plaintiff when you're being charged for a crime against the state. They're running us under that law of necessity. Whatever the necessity is at that time is what they're charging us with. This is why, with what we're doing here, we're having such a problem. And we need to grasp what is going on here, and we need to change the system. We need to start hammering. And you can't sit back and wait for, well, let's go see what this one guy can do. And if he wins, then we'll all. But if he loses it, no, ladies and gentlemen, it don't work that way. We're all in the same boat. We're all in harm's way of what's being done. There is laws against what they're doing. There are issues here of what they are doing that is illegal. I got back into the Nuremberg trial finding report, and it's under the Avalon Project. And I started doing a little bit of research on this, of what is actually going on here and what we're running into. And I think we need to start addressing this. Use the Nuremberg trial report. A scientist who developed a weapon capable of killing thousands of people. A diplomat or officials of a neutral country that helped war crime escapes. Any soldier who looted, pillaged, or damaged private property. Any government official who cooperated aiding in civilian administration with the Axis forces after their country has been conquered. A doctor who conducted medical experiments on prisoners. An officer who witnessed the rape and torture of civilians by his soldiers and did nothing. A factory owner who used prisoners as laborers to support the Axis war effort. A soldier who executed unarmed prisoners of war at the orders of his superiors. Crimes against humanity. And offenses included but not limited to murder, extermination, enslavement, deportation, imprisonment, torture, rape, or other inhumane acts committed against any civilian population or prosecution on political, racist, or religion ground, whether or not in violation of the domestic laws of the country, were perpetrated. Ladies and gentlemen, we're having a real issue here on this stuff. This is something that we need to start and we need to reconsider and quit trying to play this stupid little game with these people. We are under the state of emergency. There is absolutely no doubt in my mind that we are under a state of emergency. I just read you case laws. Now, we're not taking any calls. I'm not even supposed to be up at this time. But we are under a state of emergency. We are being charged for crimes against the state. We are being singled out because of the value that is placed on us under the state of emergency. Because we are the credit line. But ladies and gentlemen, I want you to sit back and just give it some thought here of what we are getting into and what we're talking about is that we're being charged for crimes against the state, and there doesn't have to be an injured party. All you have to have is a different opinion, and that's a crime against the state. This is why they're getting away with no affidavits. This is why they're getting away with no complaint forms. That's why they're getting away with no warrants. Don't need one for any of this. Give us some thought here tonight about what we're talking about because, ladies and gentlemen, it's very significant and very important of what we are getting into and what we are talking about. Very important because our livelihood depends on it. Our ability of what we are doing depends on it. Article 1, the purpose of this ordinance is to provide for the establishment of military tribunals which shall have the power to try and punish people charged with offenses or cognizances as crimes in Article 2 of Control Council Law Number 10, including conspirators to commit any such crime. Nothing herein shall prejudice the jurisdiction of the power of our courts established or which may establish for the court of such offenses. Ladies and gentlemen, Article 3, charges against persons to be tried in a tribunal established hereunder shall originate in the office of the chief of Council of War Crimes appointed by the military governor pursuant to paragraph 3 of Executive Order number 9679 of the President of the United States, dated 16 January 1946. I'll read that again. Executive Order number 9679. The Chief of Council of the War shall determine the person to be tried by the tribunal, and he or his designee representative shall file the indictment with the Secretary General of the Tribunal under Article 14 and shall conduct the prosecution. Ladies and gentlemen, it's something that you need to get into this too, because I tell you what, there's some good information in this. Because what was charged on the second round was judges and prosecutors and lawyers and doctors and other public officials and other non-civilian, all government. And ladies and gentlemen, that's what we're running into right now. I want you to sit back and give us some thought of what we're dealing with here, because I tell you what, it's explaining a lot. And a lot of these people are trying to kick up Admiralty, trying to kick up Maritime, trying to kick up UCC. That's why this stuff isn't working. It works if they want it to work. But when they don't, no matter what you put in, it doesn't matter. This is what we're starting to find out. But we still need to go head-to-head with this. And we still need to fight these people on this, because our freedom is at stake. We need to start putting this stuff in our paperwork. And my paperwork has been showing some of this stuff of what they're doing, of us laying it out. My paperwork is hitting the internet. It is being seen by agencies and other people that's sitting back and seeing this. This broadcast tonight was to maybe bring them up to date, because this falls back under the Lieber Code. And I also want you to come back in under Title 5. Title 5, USC 7311. Title 5, which is Government Administrative Code, Loyalty and Striking. An individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he advocates the overthrow of our constitutional form of government, is a member or an organization that he knows advocates the overthrow of our constitutional form of government, participates in strikes or access the right to strike against the government of the United States or the government of the District of Columbia, or is a member or organization and employee of the government of the United States or an individual by the government of the District of Columbia that he knows asserts the right to strike against the government of the United States or the government of the District of Columbia. Ladies and gentlemen, they cannot advocate the overthrow of the United States Constitution. And the moment they do, they're committing treason. This is a no-no. They cannot do this. Even under the rule of necessity, they cannot proceed with this on the way they are doing it. They cannot do it. But it comes up to you and I to bring this stuff forward. You and I are the ones who are going to have to bring this stuff forward. Under Title 18, 2331, which is the Patriot Act, under Section 802, to intimidate or coerce civilian population. That is exactly what they are doing. They are coercing us. They are trying to sit down and cause us and threatening us and intimidating us. That's what they are doing. Title 18, 1908, advocating the overthrow of the constitutional form of government. There's no Title 18. They cannot. Title 18, Chapter 115, Section 2381, is guilty of treason and shall suffer death. Let me go back and pull that one up. This is in their laws, ladies and gentlemen, their laws. This isn't me saying it. This is written in their law. Whoever owing allegiance to the United States, levying a war against them, or adhere to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years and fined under this title not more than $10,000, and shall be incapable of holding any public office in the United States. Is guilty of treason and shall suffer death. There it is in Title 18, 2381 under treason. This is not me making this up. This is not me sitting here putting my own interpretation in it. I read it verbatim off of their law. That's not a threat. It is thus written in their law. And that's the same thing that comes down with what we're talking about under the Lever Code. Under the Lever Code, it gets in and it addresses under Article 44, a soldier, officer, or private in an act of commission, such violence and disobedience, a superior ordering him to abstain from it may be lawfully killed on the spot by superior. All wanton violence committed against persons in the invading country, all destruction of property not commanded by an authorized officer, all robbery, all pillaging or sacking, even after taking a place by main force, all rape, wounding, maiming, or killing of such inhabitants are prohibited under the penalty of death, or says service punishable as may seem adequate for the gravity of the offense. A soldier, officer, and private. This goes right back into your public officials. In the act of committing such violence and disobedience, a superior order him to abstain. Neither officer nor soldier are allowed to make use of their position or power in a hostile country for private gain, nor even for commercial transaction, otherwise legislated. Offenses to the contrary committed by commissioned officer will be punished, and cashing or shall other punishment of the nature of the offense may be required. If by shoulder, they shall be punished according to the nature of the crime. Ladies and gentlemen, what I'm reading you here is they wrote this crap. I did not write it. We just copied it and pasted it. Think about what we're talking about here tonight, ladies and gentlemen. How do we handle being charged for crimes against the state? This is what they did to the Native Americans. They charged them for crimes against the state. That's what they're doing with us. Give it some consideration. I want to thank you for being in here tonight. Like I said, it's late. I wasn't supposed to be up this late, but I was doing paperwork. Thank you. Have a good night.